5 courses over 6 weeks, is that there'll be a guest who's going to come in and talk about something that they do with regard to law and innovation. And then there's going to be an opportunity for us collectively to interact with that person. But I want to talk about the themes that we hope to hit this semester, try to frame it a little. So the first theme is the importance of using technology to deliver better legal services. So there's sort of twin problems in legal services. On the low-income end, there are tens of millions of American people who can't effectively afford access to legal services. Now, the traditional solution to that has been to hire more legal aid attorneys. Those are people that give of themselves and they work for relatively low wages, and they help poor people with problems. Now, there simply aren't enough of those folks, and even if we were to double or triple or multiply the budget that's given to legal aid by 10, there still wouldn't be enough legal aid attorneys to handle the legal aid problems that people have. And these problems are serious. Divorce, landlord-tenant problems, problems with illness caused by environmental conditions. We have the right to an attorney when they're criminal defendants. But if they want to be civil plaintiffs in a case, if they want to sue someone for wronging them, they have no right whatsoever to do that. So we have this one problem on the low income end. How are we going to help all of those people meaningfully get access to their legal rights in good ways? There's a problem on the other end of things too. So for years, the legal market has been dictated by large law firms. Large law firms pay a lot of money for themselves, but don't do a very good job of meeting middle-income clients. So there's a stat that I'm always interested when there's new data on, and the most recent data a data point I've seen is $300 billion. And that's the estimate for the latent legal market in the United States. Latent legal market as defined as people who are in need of some sort of legal services, would like to buy some sort of legal services, but there's just no price point that they're able to make. So there's about $300 billion where people, rather than dealing with a legal problem, they don't have a will, they should get one, they know it, they just don't deal with it. It's just money left on the table. And one of the solutions proposed that can potentially fill part of that gap is the use of technology, using smart technologies to bring the cost down of providing needed legal services for people. So that's one important theme that we want to think about. How to make it so that poor people get better access, how to make it so that people who are of more adequate means want to pay for legal services, and one of the ways to do that is technology. The second that we want to think about is the set of technologies out there that have the possibility of absolutely revolutionizing the way that we approach legal problems. So the two that we'll highlight in weeks 2 and 3 of this class are artificial intelligence and blockchain technologies. So in terms of artificial intelligence, there's an open question as to if we can train AI to do a significant high-level portion of the work that traditionally paid legal professionals have been asked to do. And in so doing, just create a world that's more efficient for people to get access and to resolve legal problems that they might have. Blockchain, in theory, could rewire the whole plumbing of how people communicate in the legal world. It could change, or blockchain technology could change the way that we record information. Recording is an important part of law. So we'll hear from speakers who are experts in those areas about what they envision, the challenge they see, and they'll invite you to think about how you might get involved. The third are the challenges that these new technologies bring to existing regulatory schemes. So one of the things I always tell people when I talk about what I do is I say, I'm a technology of law guy, not a law of technology guy. In other words, I know something about the tools that make people better at delivering legal services. But the thing I'm less familiar with, frankly, is how those changes will impact the law. In other words, our current legal system isn't necessarily built to exist in a world where there are automated tools. Let me give you one example, and Dean Perlman, I think, will probably talk about this, or can talk about this later. It's illegal, it's unlawful for someone who's not a licensed attorney to offer legal advice. Well, what happens when someone creates a tool that effectively serves as a chatbot and answers a series of questions for people and effectively tells them how to behave in litigation? We have a regulatory problem there because traditionally that's work that's been reserved for real live human being lawyers who went and got a JD and passed the bar. But now we have tools that can arguably do it just as effectively, at least in some contexts, and do it at low or no cost. So there's a whole set of regulatory challenges that arise here. And one of the wonderful things about being in the MIT environment is One of the things that folks are encouraged to do here is not just think about little tweaks we can make, but how we could start again totally anew and reinvent a system that would account for this technology and make it more effective. So those are the three main themes that we're going to talk about over the next few weeks. And today's speaker is someone that knows all about those themes. So let me just talk a little bit about Dean Andy Perlman, who's going to give a presentation in just a few minutes. So Dean Perlman is the Dean of Suffolk University Law School, and he was also and has also been deeply involved in the regulation of attorneys over the course of his career. He was the chief reporter of the ABA's 2020 Ethics Commission, which changed the ethical rules to reflect the need to understand and be competent in technology. He was the vice chair of the ABA's Commission on the Future of Legal Services. He was appointed by the ABA president to chair the governing council of the ABA's Center on Innovation. He started the Institute on Law Practice, Technology, and Innovation at Suffolk Law. I succeeded him in that role, but he was the first law school professor to effectively say, we need an entire program in technology and innovation. So today he's going to come and share with us some of that deep knowledge that he's got in terms of thinking about technology, innovation, and the role of those things in delivery of legal services. So Andy, thank you for being here.
Sure, thank you for having me. Before I jump in, I want to highlight something that Professor Tenenbaum mentioned, which is the difference between the technology of law and the law of technology. Because to understand what we mean when we say future law, it's important to understand that distinction. Traditionally, when we think about innovation in law, we think about innovation in companies and businesses and industries that are out there and the regulatory and legal infrastructure that affects what they do. Let's say patent law or trademark law or a wide range of legal issues that entrepreneurs and innovators face. This is, for all intents and purposes, the law of innovation or the law of technology and innovation. Very important, and I'm sure you're going to touch on those issues in this course. What I'm very interested in is the flip of that, the law of technology and innovation of law. So instead of the technology, or I should say the law of technology, I'm interested in the technology and innovation of law practice. How do we deliver legal services in new ways? Because for all of the reasons that you heard, not being delivered in the way that the public needs, legal services are too expensive, and there is a desperate need to innovate the way that the public receives the legal services that they so desperately want and don't want to have to overpay for. So that's what I mean when I say that I want to think through what kinds of changes do we need to bring about in the delivery of legal services. Okay, so that's what I'm going to talk about. But I think to understand future law, we need to take a step backwards and think about where we've come from. The way that legal services have traditionally been delivered looks a little like what you see on the screen. A couple of old guys sitting around a table with some papers in their hands and some books on the shelves. That's what we think of. That's the popular imagination of legal services delivery. And there are certain words that come to mind when we think about the way that legal services were delivered in the past. Papers, books, people went to trial a lot, and when you watch movies about legal services, you see people standing in a courtroom. Typically, lawyers practice alone. By far, the most common practice setting was a solo practice setting, a single lawyer, and they were generalists. They handled anything that came through the door, and they handled it from soup to nuts. There was no specialization. There was no outsourcing. There was no giving it to an associate. Lawyers did it all. So that's the way legal services were delivered a century ago. But when we think about legal services today, there's an entirely new vocabulary that comes to mind. And whether you're lawyers or law students or people who are just interested in the subject, some of these terms will be familiar to you. Many of the terms will be familiar. And they are starting to make their way into the delivery of legal services. And they can best be characterized by the two words of rapid change. So in light of these rapid changes that are taking place in the legal industry and the delivery of legal services, the question that I am often asked is, what is the typical lawyer reaction? Now, I am a professor by training, and I like multiple choice questions, and this one has only two possible answers, so it'll make it easy on you. So is the typical lawyer reaction like this? Bonus points for anyone who can name the character.
In his Borg form.
Thank you. Locutus of
Locutus of Borg.
If I figured if there was any audience that would know the answer to this question, it would be a
It's not
lecture at
Picard
MIT.
anymore.
So I'm very grateful.
I'd say legally that person is not Picard and could not ever be charged as Picard.
Okay.
In a crime.
Okay, raises a different set of legal issues, but thank you for teeing them up. So yeah, do lawyers equip themselves and become one with technology and affect everything that they do? Or the other possible answer is this, with the heads in the sand. And I can tell you when I give this presentation to a room full of lawyers, there's widespread laughter about the second option. And the reason there's so much laughter is it's a sense of recognition that this is the most common reaction that lawyers have when they see the world changing around them. When they see so much use of technology and innovation, they are not really changing. And the question is why? Why is the legal profession so slow to change? And here is where I'm going to take some of the blame. And when I say I mean law schools and legal education in general. And here, again, I want to take us back in time. It's important for those of you who are not lawyers to understand a little bit about legal education that will help you understand why the profession is so slow to change and why there are so many issues of the sort that Professor Tenenbaum referenced. So let's go back more than 100 years ago and think about the way that lawyers were trained at the time of that opening slide with the two old guys sitting around the table. So legal education in the past was pioneered by this gentleman here, Christopher Columbus Langdale, at a law school not so far away from here. And prior to Langdale's innovation, the way that lawyers were trained was either they had an apprenticeship, they worked for a lawyer, they learned the way that it was done, or they simply learned the law by reading what were called treatises. They read descriptions of law, but not the actual primary materials, not the law itself. It just described the legal, what's called legal doctrine. What Langdale came up with was a new approach. He said, why don't we have law students read cases, that is court opinions, be able to teach those students how to extract principles from those cases and then apply principles to a new set of facts they've never seen before. This was known as the case method of legal instruction, and it spread to just about every law school in the country. Now let's fast forward from Langdale's time, because that was more than 100 years ago, and ask the question, what does legal education look like today? Well, here's the answer. It looks pretty much like the same guy, Christopher Columbus Langdale. Now, to be fair to law schools, and there's nobody who wants to be more fair to law schools than the dean of one, we have pushed Langdale off to the side, and we have incorporated new doctrines, new courses, new substantive areas of law, and we've also introduced new skills, more legal writing training, clinical courses where students are trained to represent clients in real situations, all very important developments in legal education. But at the end of the day, students are still trained to look backwards. The law is inherently backwards looking. It's about precedents and the way things were done in the past, rather than looking to the future. So here's a quote by hockey great Wayne Gretzky: "Skate to where the puck's going, not where it is right now." And there's a legal futurist, a guy named Richard Susskind, who uses this quote to make the point about what we need to do with regard to the future of legal services. And I think it's a wonderful concept. But you might ask, if this is about future law and it's about where the puck is going, we need to understand where that puck is actually going. To understand that, there's this picture, this image that Richard Susskind put in his book, The End of Lawyers, and I've used his British spelling here. And I'm going to walk through this with you because I think you really need to understand it in order to see where services are going to be going in the future and to truly understand the future of law. Let's start with bespoke. How many of you are familiar with this term, bespoke? Only a small number of you. It's a British phrase, means highly tailored, custom approach. So oftentimes used in the context of clothes. If you're going to buy a bespoke suit, you've got a tailor who takes your measurements and crafts a perfectly tailored suit for your needs. So in case you are curious, This, unfortunately, is not a bespoke suit. But you can buy one and they're more expensive. That's the point, because they are custom tailored. Now, legal services, historically, are bespoke in the sense that there is a client who has a need, comes into a lawyer, and goes through a very custom tailored process to deliver the services that that client needs. A series of questions and answers, and developing the ultimate service for that client. Now, as a particular service is delivered more routinely, you can standardize some features of it. Law often involves documents, whether it's a litigation or dispute between parties or a kind of transaction. Very often there's a document that's needed, or many documents that are needed. And those can be systematized, or I should say standardized. Certain phrases, certain clauses, certain sentences, maybe even entire documents might look the same from one legal matter to the next. So instead of being bespoke, you can standardize certain features of the service. Over time, those services, those documents can be systematized. That is, they can be created in a much more efficient way so that you don't have to do it over and over again in a custom, highly tailored approach. And of course, when you do that, you can drive down the cost of the legal service. Eventually, it becomes so easy to create and deliver that service that you can turn it around, make it available to the public, and allow the public to do it on its own. This is a packaged legal service, and at some point, the service is so easy to generate, so costless to produce, that it is, for all intents and purposes, a commodity. So let me give you an example of one service that I think has gone through this transition. If it's not there yet, it's getting pretty close, which is the creation of a basic will. Whether you've gone to law school or not, you understand what a will is. Now, to create one used to be a largely bespoke process. You would have to go into a lawyer, physically go into a lawyer. The lawyer would ask a variety of questions, and based on the answers to those questions, draft a will. And the drafting of the will was done on a typewriter from scratch. Now, maybe you would have certain standardized features in that will, but for the most part, it was done from scratch each and every time. It was a largely bespoke process, and it's not so long ago that that was the case. Let's benchmark it around 1980. Now, let's fast forward from 1980 to today. I think what you find is basic wills, if they are not a commodity yet, they are rapidly approaching it. I do not advise any law students in the room, and I see a few, to go into a practice where the primary way of earning a living is generating basic wills for individuals. That is not going to be around for much longer, and there's not going to be much money to be made in it. Now let's think about transactions, and wills are a sort of transactional service more generally. What we're finding is a splintering of the marketplace where legal services, transactional legal services, are being delivered at different points along the spectrum that I just described. So on the commoditized end, not just basic wills, but if you wanted to incorporate a small business, you could do that on your own. Government websites have the forms that you need. There is just not much money to be made from incorporating a small business. Now let's move one step up. How many of you have heard of LegalZoom? I'm not surprised. They are the most recognized legal brand in the United States, more recognized than any law firm, and they are not a law firm. They are a company. And we can get into a wide range of regulatory issues that were referenced before, and if people have questions about it, happy to talk about it. But what LegalZoom is really a packaged legal services provider, right? They have taken all of the legal knowledge, they have turned it around for the public to access on its own for a fee. So they're a packaged legal service provider, and they deliver a wide range of transactional services to people who want them at a very low cost. So innovation is driving down the cost through largely automated document assembly. Now let's go one step up from that. So standardized. Great example here are closings, real estate closings, okay? So what you could do is use technology. It used to be the case you would have to generate document after document. How many of you have either bought a home or refied? A number of you. And if you've gone through that process, you see oftentimes a large stack of documents that you have to go through. To produce that large stack of documents without technology would be very resource intensive, take a lot of time, and be costly, unnecessarily costly. And so what some innovators have done is use technology to standardize that process, driving down the cost of real estate closings. We actually happen to have one of them in the class here, Costa Ligres, who built a business around that concept, and as a result is one of the leading providers in New England. I might go so far as to say the leading provider in New England. Am I overstating? No, I'm not. Okay, very good. And so he's done that through the standardization, or I should say systemization, of the delivery of certain kind of legal services. So there's still considerable money that could be made if you know how to use the technology to drive down those costs. So that's an example of future law through the standardization, or I should say systemization of documents. The problem is the legal profession, because of the training that we go through, continues to blind us from these other possibilities, and we deliver those services in a primarily bespoke way, even though there are all of these opportunities at different points along the spectrum. And same is true for what is known as litigation or dispute resolution. We're seeing a splintering here as well. Let me give you an example of a commoditized legal services provider in the dispute resolution realm, and that is Modria. How many of you have heard of Modria? Okay, I'm not surprised. There's only one hand that went up, and this is the surprising aspect of the lack of recognition of who Modria is, or what Modria is that they resolve more disputes in the United States than the entire U.S. court system combined, which is a remarkable statement. So you might have to wonder, what is Modria? Well, Modria was created to help resolve disputes on eBay and PayPal. So let me give you an example of what Modria does. A few years ago, I bought a television and at Best Buy, and I received a Best Buy gift card that I didn't need. So I decided to sell it on eBay. Put it up, somebody bought it. I put the gift card in an envelope, put a stamp on it, put it in the mail, after I got paid, of course. And then a week later, the person claimed, what's up? Why didn't you send me the gift card? I said, well, I did. I put it in the mail. And the person said, well, I want my money back. I checked into the gift card and it had been spent. So it wasn't lost somewhere in some dark corner of the mailroom. So how do we resolve it? There wasn't enough money at stake to go hire a lawyer or go in a small claims court. What Modria did was build an online dispute resolution platform for eBay and PayPal so that consumers could resolve their own disputes in an automated way through what is called an expert system tool, branching questions and answers that ultimately lead to an outcome. In my case, we went through this process, and I was ultimately asked the question, did I have any evidence that I had sent this gift card in the mail? Return receipt, anything? The answer was no, because I stuck the gift card, so me, in an envelope, put it in the mail. And according to eBay's terms of service, this means I'm out of luck, and I have to give the buyer the money back. I can tell you, as a former trial lawyer myself, this was infuriating to have lost this particular dispute, but I also can tell you that I thought the outcome was fair. It was fair because I felt that the policies were pretty clear, and it was my fault for not actually documenting that I had sent it. But it's a wonderful example of a commoditized delivery of a dispute resolution process. Court kiosks and courthouse, we're seeing them more often. They are packaged in the sense they are outward facing, they are giving the public the services that they need in a different kind of way. Lawyers who do dispute resolution are frequently producing documents called pleadings and discovery. All of that, or much of that now, can be automated and systematized. But once again, lawyers who are engaged in dispute resolution work think in largely bespoke ways. And even at the bespoke level, there are some changes taking place. I know later in this course, you're going to be learning about AI and blockchain as they might apply to legal services, and we're still at very early days in terms of this. IBM Watson has a legal division that's doing work in this area, and they're developing a number of possible solutions. Time will tell what that all looks like and the impact that it will have on the delivery of legal services. But there already is some indication that some of the largest clients and companies in the world are trying to take advantage of AI to rapidly reduce the cost of some kinds of legal services that they need. Bottom line, from my perspective, legal services, future law, it all needs to be rethought. We need to be thinking outside of the bespoke box. So what are law firms and in-house, that is corporate clients, doing? What are the solutions that they are developing in light of all of these changes in the industry? This is just a sample. By far, this is not an inclusive or a completely inclusive list. Many of them have legal project management departments. So the project management is a concept and a skill that has been around for decades, often used in manufacturing. It's making its way into other industries, including in law. Process improvement as well. Automated document assembly are already referenced, companies like LegalZoom, but there's certainly many others out there, including some that focus their efforts on the corporate side. The real estate closing business is an example of automated document assembly. Expert system tools that can give people the answers to commonly asked questions without the need for a human being, and taking care of that very bottom level, easy to answer legal questions. Then you have AI, like I said, still open question what impact that's going to have. Managed legal services, legal process outsourcing, all of these new providers that are emerging, and we can get into some interesting regulatory issues about whether they are delivering legal services or not. But whether they are or not, they're doing it. They are delivering all sorts of law-like services to very sophisticated corporate legal departments. Alternative fee arrangements as incentives for greater efficiency. By this I mean the largest companies in the world. Microsoft recently did this. They told their outside counsel in certain kinds of cases they are not going to allow their lawyers to bill by the hour anymore, period. And guess what happens when lawyers don't make more money when they spend more time on a legal matter? Suddenly, innovation becomes a lot more important because they're not going to make money unless they deliver the services more efficiently. So as clients start to wise up and request and demand alternative fee arrangements, we are going to still see things the way that they have been. So AFAs and their demand for AFAs is an important development. Law firms and legal departments have, for all intents and purposes, R&D departments. So a couple of major firms, Dentons is one, Seyfarth is another, Davis Wright Tremaine. These are all large firms that are developing new approaches inside their law firms. And then there are in-house legal teams that are doing the same. Liberty Mutual here in Boston is a good example of it. And then Gabe mentioned blockchain, and there's an effort to standardize blockchain in the context of law. Still early days, as I mentioned before. Okay, responses by law schools. As I mentioned, that Christopher Columbus Langdell image is a problematic one. Schools doing in this regard? Well, we're starting to change. This group of law schools have efforts, much like Suffolk has built, to try to deliver to students a new mindset, a new way of thinking about how legal services could be delivered using technology and other innovations. And I'll just very briefly mention this institute that we have. We have a concentration, which is kind of like a law school major. Many law schools have law school concentrations or majors in standard areas like intellectual property or international law or areas like that. We built one around legal technology and innovation, where we're teaching our students about legal project management and process improvement and automated document assembly and expert system tools. And they are getting some really remarkable employment of the sort that you see on the screen. And our challenge is actually finding enough students to fill the demands, convincing our students that this is a really powerful and impactful area to pursue. So we are having trouble meeting the demand that we're seeing in the marketplace. So I'll close with some pictures and think about just the ways in which so many other industries in our world have undergone change. You think about this company, those of you who are young in the room may not remember this, but in order to watch a movie that wasn't on TV on a broadcast channel, we used to have to go to a store and rent either a VHS tape or a DVD. Obviously, times have changed and technology has come up with new solutions for that. Then we had shopping. Well, we still go to stores, right? But I very rarely go to one these days because there are technological solutions for that. Even taking pictures has undergone a remarkable transformation as a result of technology. And then people services, right? You might say, well, law isn't like those. It's not it's more of a people business and need judgment. Well, cabs are a people service, and that's been disrupted by technology, but you might resist still and say, well, that's not professional services. Professional services are a different animal. You might, banking. Well, a lot of people have lost their jobs in banking due to technology, but you might say still, no, let's kind of talk about real professions like accounting. Well, I don't know about you. How do you do your banking, your accounting and taxes? I do mine online. And so that has disrupted a major profession. And the ultimate question, I think, that we face in legal education, in the legal profession, is what is the next picture that I am going to put up there after this one? What is the analogous slide that I put up? That is a question I think that you are all going to be dealing with in this course. Future Law is about the answer to that question about what comes next. It's an exciting time to be in the delivery of legal services. Innovation is starting to take place all around us, and those people who are thinking about it and on the cutting edge have an enormous opportunity, and so it's an exciting time. So I applaud all of you for trying to tackle these issues in this course, and I'd be happy to answer questions that people might have.
If folks have questions for Dean Perlman, you can call people, or you can call people, but please get your hands up and ask away. And I'm glad to ask a framing question today. So one of the challenges is the question of regulation of lawyers. Who is entitled to give legal advice? And if one of the entrepreneurial spirits in this room says, I want to build a tool that does X, that tries cases or does real estate closing documents, is there a risk of them running afoul? So would you comment on sort of the line of what amounts to providing legal services and how smart technologists can think about that line and how to go over?
This is one of the biggest regulatory challenges in this area, defining what is the practice of law. So nearly every state in the country has restrictions and prohibitions against what's called the unauthorized practice of law. People who are not lawyers practicing law for all intents and purposes. And the question comes up, what is the practice of law for purposes of these laws? And the answer not only varies from state to state, but even within a particular state is incredibly vague, to the point where courts have actually come out and said, able to define what the practice of law is. Now think about the ridiculousness of judges who are themselves lawyers being unable to define what it is that they do. But that is the problem of the unauthorized practice of law. And to be quite frank, many times unauthorized practice of law provisions have been used not to protect the public, which is the basic reason that these exist, but to protect the legal profession itself from competition, which is the worst possible reason to have unauthorized practice of law provisions. And so this is a long way of saying it's an incredibly unsettled area of law, and as a result, legal tech and innovation companies, especially when they are consumer-facing as opposed to delivering services to corporate clients, regulators tend not to care about that so much, but when they are delivering services directly to consumers is when the issue tends to come up. So LegalZoom has been the subject of lawsuits in several different states. So far, they have survived all of them, sometimes with having to tailor some changes to what they do in particular states, but for the most part, they have survived those challenges. But it's a real significant risk for innovators in the United States who want to go in and try to do something different, that they could run up against this particular challenge, depending on what segment of the industry that they are looking at and the ways in which they deliver services. So long answer to your question, but the answer is very unclear, unfortunately. And it's a problem. Yes?
To what extent do you think that the partnership structure is and why is there so much resistance? Not from the ABA, because I've read the report, which does propose that in certain instances, non-lawyers should be allowed to have a Why is there so much resistance to that change?
Oh boy, that is a very insightful question, and it goes, and it, in many ways goes. Yeah.
Can you restate the question?
Sure. So the question is, so I would say, if I may, to rephrase it slightly, two different parts to your question. To what extent are the restrictions on lawyers' ability to partner with other professionals, inhibiting innovation? And then why is there so much resistance to allowing lawyers to engage in different kind of ownership structures within their law firms? So on the question about is it inhibiting innovation, the available evidence, which a few years ago was hard to come by, there's more evidence that is emerging from other countries. Maybe before I answer fully, I should take a step back because we might be operating with more knowledge than there is in the room. So let me take one step back. In the United States, unlike some countries, lawyers are not permitted to partner with and share fees with people who are not lawyers. So if I develop a law firm, ABC law firm, I cannot partner with an accounting firm or a consulting firm. It's not permitted. I can't share fees with them. I can't take an equity investor in my law firm and share the profits that are generated with the equity investor if that investor is not a lawyer. It's not permissible. It's prohibited under the rules of professional conduct, or Rule 5.4 is the prohibition. Other countries have liberalized this area and are allowing lawyers to partner with other kinds of professionals. And there is some evidence that that is bringing about some innovation, that it might be a way to drive more innovation in the delivery of legal services is if you free up that restriction and allow it. Now, the question you asked, why is there so much restriction in the United States to liberalizing this rule and allowing what is now permissible in places like the UK and Australia? The answer is, I give you the, there's a cynical answer to your question, and then there is what people are saying. What people are saying is that if you allow lawyers and law firms to partner with other professionals and give them equity stakes in law practices, that it would jeopardize the professional independence of the legal services that are being delivered, that law firms would for all intents and purposes, become businesses and not care about their clients, ultimate public that we are supposed to serve. That's the argument. Now I see you're smirking, perhaps appropriately so, because after all, law firms and law practices, you are businesses, and lawyers have to navigate those issues and should exercise professional independence, whether they have an equity investor or not. If you think about lawyers who work inside of corporations and who are general counsel of corporations, they have a single client. They are inside of a company, and yet we trust them to do the right thing, to exercise professional independence, despite the fact that their salary, perhaps their stock options are all tied to that company. We trust them to be professionally independent and to do the right thing. But for some reason, we don't allow that of law firms. So that's a long way of saying my own personal view is that the restrictions in this area are too significant and that we need liberalization of Rule 5.4. The professional arguments that have been made against that liberalization, I don't think hold up under careful scrutiny. And the cynical answer to the question is, it's really about protectionism and the concern that others will take over various kinds of law practices and that the profits to be made for the lawyers will suffer as a result. I think that is the concern that underlies many of the arguments that you see out there. That's just a personal opinion, but that's what I think is going on.
So I just have one very quick follow-up about that. So do you think that we'll see enterprising, perhaps in this room, taking advantage of the fact that there are probably workarounds in terms of structure? So having legal services done you can have part ownership in DC, and there are a couple of other jurisdictions in the States, but certainly part ownership in the US or the UK.
Yes.
That's about to happen, right?
Yes. Well, you've taken this to like the advanced level discussion of the regulation of legal service. I love it. And before I became dean, I got calls of that sort about how do we navigate those regulatory issues. So there are some jurisdictions in the U.S. that have more liberalized approaches to this issue. You mentioned Washington, D.C. The problem is, if you're going to build some kind of enterprise to scale, jurisdiction, you're ultimately going to have to operate in other jurisdictions. So just because you create yourself in DC doesn't mean you won't run into other problems elsewhere, which is why the fact that DC has a more liberalized rule hasn't led to an emergence of companies creating themselves in DC and then serving the rest of the country. Hasn't happened. So that's not the answer. And creating yourself in the UK or Australia, it doesn't get you into the US, because once you start going into the US to deliver services for reasons of what are called choice of law principles, you would be subject to the laws of the United States and the jurisdiction in which you're delivering the services. So that is not a solution either. The best workarounds tend to be either focusing on the corporate end and the reason that it's useful to focus on the corporate end is if there is a general counsel who is ultimately responsible for the services that you are delivering to a company, you have a lawyer who's overseeing it, and you might argue either if it is a legal services, it's under the direction of the lawyer, or that it's not really the practice of law, that there is this distinction between the delivery of legal services and the practice of law. So for the moment, corporate innovations in corporate legal services have not been challenged the same way that the delivery of consumer legal services have. Again, could be a much longer conversation, but there are various companies that already exist that are trying to get around this issue. I mean, LegalZoom is an example, right? They're not a law firm. And if they were actually, quote unquote, practicing law, what they would be doing would be impermissible in just about every US jurisdiction. So the way they've navigated is to very carefully craft their services in a way so that it does not count as the practice of law. So again, long answer to a short question, but a conversation that could take us in much more depth. Yes?
So I'm pretty new to the law, so excuse things that I might be unaware of, but this LegalZoom and the unauthorized practice, is that a civil case or a criminal case? To verify that. And if it is civil, who are the plaintiffs? Is it the state bodies themselves criminal case? Is it bar association?
Great question. So when we're talking about a company like LegalZoom, if they are the subject of a challenge in a particular state on the grounds that they are engaged in the unauthorized practice of law, you're asking, is that civil or criminal? It depends on the jurisdiction. And by the way, you may start to get the hang of this, that a law professor's favorite answer is it depends. And once again, it really does depend. So some states view the unauthorized practice of law as a civil violation, some view it as criminal, so it could be either one. And who brings it also varies from jurisdiction to jurisdiction. Sometimes there are committees, adjuncts to the courts that do it, sometimes not. So it really does vary a lot from jurisdiction to jurisdiction.
So this line of inquiry can be generalized, because in some sense, one thing we realize here is the future is not evenly distributed planet-wide. And so this idea of seeking out microcosms where things are being pushed ahead of the rest of the planet, or jurisdictions, can you sort of generalize on this particular conversation around the structure of law firms and who can practice law, and say what parts of the planet, what predictive microcosms, or what exploratory jurisdictions are the most friendly to trying on new ideas, with the thinking being that when prototyped there, those who are doing it there are in the best position to expand these ideas elsewhere rapidly, given that things are increasingly digital, that what was a jurisdiction is now increasingly cloudable, that is to say, blurring lines very quickly.
So I would say in terms of legal innovation, for the reasons that we were talking about in terms of the regulatory landscape, currently places like the UK and Australia are the most friendly in terms of legal innovations. If you really, for certain kinds of legal innovations, those would be the most friendly places. Especially if you're actually going out there and practicing law in a new way, those would be the places where it would be, I would be wanting to be an innovator. If you're a LegalZoom of the world, it's a little bit harder to say, because who is going to go after you for the unauthorized practice of law and really depend on who chairs a particular committee, and who's in charge of the unauthorized practice of law in the state. That one's a little bit tougher to square, with the proviso that there is at least one U.S. jurisdiction that allows lawyers to partner with others, and that being the District of Columbia. Here and then over there.
I was particularly curious about your Madrid, and I'm wondering, where do you see the other party financial or but still having some kind of execution system whereby resolved or filed? Where do you see those in, where do you see them like right around those kind of service
Let me make sure I understand your question. So other kinds of legal professionals who are now being involved in the delivery of legal services, is that your question?
Almost like you're setting up your own, in a way, when you create a service, but if you're setting up your own route, right, for how you send go about things, and it seems that they take their own system and manage those. So, do you see other places that's the shape
that are analogous where the
well, it's not the local map. It's not like the rest of the world. It's either continuity or outside of the
alternative structures. I mean, I think those have existed. You know, there's alternative dispute resolution that is taking place outside of the courts, and there are all kinds of regulatory structures that people will buy into as a result. I'm not sure. Dave may have a better answer.
If you don't mind me chiming in, so there's a whole alternative legal system in the United States involving arbitration, and in consumer products, people can opt into arbitration, and opt-in is really in quotes. Sometimes you can't use a product without opting in, and at that point you become subject to the legal regime that you've agreed to by contract, and the things that you are subjected to are things that would never be passable in court of law. And there's been a Supreme Court litigation in the last few years that says that these are enforceable in almost every imaginable situation, including things like elderly people checking into a nursing home and waiving liability because they're being malpracticed and they're alive to get injured. They say those elderly people, as long as they're of sound mind, can opt in arbitration. So I'm sorry to step on those.
Yeah, arbitration is
that's an example of
yeah.
a totally private, independent, and basically, as long as it doesn't violate your constitutional rights, you're stuck with that system.
Regarding the general accessibility of legal services, do you see those advances as being something that are more beneficial to those in the bottom of the pyramid, those with less capital to spend, or would these be, let's say, weaponized for the usual entities that already have a lot of power to create fair legal lawsuits?
Yeah, you know, the standard models of disruption suggest that it happens at the bottom and works its way up. And to some extent that has been true, although right now we are seeing disruption really throughout the industry, including at the high end of services. I would say right now I'm seeing it at all points along the spectrum, from high end down to the consumer end, and everywhere in between. I'm not sure if one is necessarily ahead of the other. I'm curious to hear if Gabe has a different perception.
No, I don't. But there's an incredible amount of money that's starting to flow into changes at the high end, which might affect trickle down. So one example is major international law firm called Denton now has its own incubator, which they call Next Law Labs, and they're using that to finance legal tech companies. So one gentleman's question was, why can't lawyers partner with non-lawyers in a law firm? They can, but lawyers can invest in vehicles that are not law firms and effectively own a legal tech company. So Denton's with Next Law Labs is an example of a company, law firm that's spending tens of millions in legal disruptive enterprises that are, and there's a dozen or so. You can go on their website, nextlawlabs.com, and some of those companies are going to change things very often in our industry. Others seek to serve really poor people and provide just that bit of legal service.
At a high level, I'm wondering how all this technology impacts the notion of the rule of law. When I went to law school, the whole concept of the rule of law was that treat similar situations similarly, and to be this greater fairness and equality. All that. I don't necessarily see that happening. I'm curious, how you vision the impact of technological change on the concept of the rule of law.
Yeah, I think it'll be a very positive one. I think the rule of law depends on people getting access to the basic legal services that they need. And right now, all of the evidence suggests that they're not. In the United States, various statistics show, and I'm sure you know them, 80% of the legal needs of the poor are going unmet. And so it seems to me that technology, appropriately applied, can help drive down that percentage. And if you do that, then I think people, if you give them more access to the essential legal services that they need, is a core part of what we mean when we say the rule of law, that law is actually accessible to people, that they can get the basic legal services that they need in a particular situation. So I view technology and innovation as a critical component of the rule of law itself that I think is under threat in the way that we are delivering legal services today. If you have a different view, I'm interested to hear it.
Well, I'm just, when you enable the privatization of the legal system, not really reporting precedent.
Oh, I see. So you could, so if you're thinking about Modri as an example, right, ODR, it's taking it outside of the court system. But what's interesting, and I know you know this, courts are now using those same kinds of solutions so that we now have court-annexed online dispute resolution tools. So an increasing number of courts are taking the technology that was developed in the private sector, bringing it into the public sector. So I don't think the fact that it emerged in the private sector necessarily means that it will remain there. It can be used in the public sector as well in a way that I think ultimately advances the law. So ODR, I think, is a nice example.
Thanks. So we'll hear in a moment from Ghost about the project and hands-on aspect of this course. But one of the best things at MIT, I think, are legal hackathons. And credit where it's due, Suffolk Law was the first law school to do a proper, awesome legal hackathon anywhere around here. And I want to follow up on, I want to say the best legal hackathon project idea I've ever heard in any country that you brought to MIT years ago now. And just ask you if you remember it, or I can outline it for you.
I think I do remember it.
I just want to, it was premature then. It is not premature now. Any of these students could do it as a project, and I just, even if no one does, I'd like to activate and spark people's creative thinking about what is possible, the intelligent introduction of tech to law. Can you say it? Like, say the project. And
yeah, so
activate.
in my recollection of it, and I think you give it more credit than it deserves, this particular idea, but what I struggled with is legislative drafting. And the idea that rules and laws that are drafted ultimately have all sorts of ambiguities that people didn't anticipate when they drafted the words. And that you could crowdsource draft language and ask people what they think it means in a variety of circumstances that might be commonly encountered, and uncover the extent to which language has ambiguities that the drafters did not anticipate. And that you could have an iterative process using technology that would allow people, drafters of either regulations or administrative agencies or legislatures, to go back and rewrite basic legal terms in order to ensure that they have the meaning that was intended. I think that was the idea.
That was the idea.
I'm somewhat less optimistic about its potential, but I'm glad you thought it was so wonderful.
I do. And so just consider this. If you guys want to try a crowdsource thing, we've got a lot of tools just laying around the media lab today that could be configured to do what Andy just said, what Dean Perlman just said.
Andy's fine.
Thanks. Used to be Andy. Then do it. And I'll sign up with anyone that wants to hack it. You will learn a great deal about the nature of the law, what the issues are, and what it would take to begin to systematize it such that it could be productized as a reliable, quality controllable service with predictable legal outcomes. And that's what your hack would enable with statistical probability certainty. well inside, I think, ISO 9000 standards, the way you hooked it up.
I mean, the other way you could use it is not just in the public setting with legislative, with bills or rules, but you could also use it in the private sector for a contract language, just as an example, right? There's all sorts of language in transactional documents that the language is not always clear, so you could use a tool like this to try to figure out how people would perceive this language and what it might mean. If that language were ever litigated and went to a jury for some kind of resolution, it might give you some useful feedback.
Here.
Yes.
Kind of going over that a little bit. What's been done in terms of technique factoring?
Good question. So, just making sense of the words that are used in either legal documents or other kinds. Yeah. I'm actually going to turn to Gabe. I bet you he has a better answer than what I would give on this one.
Well, I teach legal writing on other things. So the answer is that there are various software packages that people use to make sure that the language that they're applying to the contract. I think the challenge is that law is a profession where sometimes can be valuable. So one of the first lessons law students learn is that when they read a case decision, a piece of precedent to apply, there's sometimes a reason that a judge or a finder of fact leaves something open. They don't explicitly state, here's the set of mental leaps I've made. So there have been efforts made to sort of close the gaps or make tools available. So there's a movement called the Simplify the Law movement. There's been a movement within something that all law students hate called legal citation. There's a book called the Blue Book that's been totally rewritten to be approachable and as a citation method. But there's some aspects of law where people behave with intentional ambiguity. So it's interesting. So Andy's hack idea, which I agree is terrific, and I would love it if we pursued it. One of the pieces of pushback to that, this tool that would make all legislation 100% clear is you're going to find legislators who say, "Oh, wait a minute, I don't want to make it 100% clear. It gave me political cover not to do with that." And maybe they would say that, but that would be what they're thinking. So there is a tension there between can we be 100% crystal clear and can we provide ourselves cover? And there are tools available, but there are reasons not to.
Yeah, Gabe's last point about intentional ambiguity is an important one because I've been involved in drafting rules, and words like reasonable are often used as a way to try to get a basic concept out, but we all know that what's considered reasonable is going to vary depending on who's interpreting it. Sometimes that's the best answer that you can give. So, but a tool like the one I was describing might still be useful because if you insert the word reasonable, you could get feedback on how people perceive what's reasonable in that particular circumstance. So that might be useful feedback in and of itself, even though you recognize the word you're using is ambiguous. How that ambiguous word would be applied in particular situations might give some value.
I'm sorry, may I very quickly also add a spin to that, which I think makes it more engineerable and a better project for MIT and our collaborator students to tackle. So, when I was doing legislation, I cut my teeth on deliberate ambiguity. It's sometimes the only way with certain things you agree, you don't agree, and you have to fudge it, and then you get the legislation done. So one of the questions we frequently had, especially in the Commerce Committee with early commerce stuff and other things where we didn't know about taxes yet, we didn't know about other things, is whether our ambiguous language was correctly ambiguous so that we didn't accidentally define things we didn't feel like or make other problems we didn't want to do. Crowdsourcing, having crowdsource the ability to ask people, is this language, do you think this language in legislation A would cause a taxable event, B would not cause a taxable event, or C would in no way addresses whether this is a taxable event. If everybody, according to our threshold of confidence said, we think it doesn't address it, we'd be like, okay, sweet, keep that in there for the next markup. If some people thought they did address, which we frequently find out later, then that was bad or would kill the bill. I think your tool is good irrespective of the goals of the law, so we can begin to adjust goals and outcomes to the legal language, which previously had no point of contact.
Yeah. Imagine, for example, that you're a lobbyist in a particular industry, and you're advocating for, or might think about advocating for a particular language in a bill. You might get a collection of ultimate decision decision makers, maybe former judges, to sit in a room and you go, or a universe of them out in the cloud and ask them to respond to different versions of the language, and based on what you receive, then could lobby in favor of particular language in light of the expert opinion that you're getting. So that, I suppose you could have that use.
Just to add to that, sitting inside MIT, talking about words, and words today are very much significant technology, search, and that they're all zeros and ones, and we're all on the same network. So we have the ability to let all these words and search and find the meaning, context, or the sentiment used. But, what do they really mean when they use the word emolument? Who wrote something in 17? We have more technology today to research and put consensus on that than ever before. It seems like a very exciting time to play that.
Okay, well, you're convincing me it's not a terrible idea.
Best legal hack I've ever heard.
Oh, thank you.
One more question.
Yeah, go ahead.
Your presentation, I think, painted a very favorable picture of the trend. I'm wondering what your top concerns are, though, as the legal field adopts technology such as.
So I've heard a number of concerns raised. One is a concern that the best legal services are still the kind that a lawyer could deliver in a bespoke fashion. And that we might lose out on that very important work that's being done, particularly efforts to change the law in socially valuable ways. That if we have fewer lawyers who are able to undertake the bespoke work, that it ultimately could undermine the advancement of law itself. That if all you do is automate and systematize the delivery of legal services, we lose out on that very important aspect of what the legal profession has always pursued, which is advancing law in socially useful ways. That's one of the arguments that I've heard. I don't think the two are mutually exclusive myself. I think we can do all of this automation and there will still be work for lawyers. One of the big questions out there, well, what is the future of lawyers? I still think there's going to be plenty of work to be done, but the work that lawyers do is going to be the stuff that has to remain bespoke in some ways, where the expression that I've always loved is that lawyers will be practicing at the top of their licenses. They won't be doing the more routine work. They can focus on that more socially valuable, very difficult work that cannot be automated, or at least can't be automated yet.
Field of medicine.
Very similar, going through a very similar process. Yep.
Sorry,
Yeah, go
I
ahead.
was just wondering, I suppose information security vulnerabilities are another concern to the increasing technology automation of law. To what extent is that a reality or a concern today?
It's a huge concern, but it's a concern not because of all of the new ways of delivering legal services. It's actually standard law firms that are encountering the cybersecurity problems, and hackers are targeting the law firms that represent the biggest companies in the world, because oftentimes the law firms are the weakest link in the cybersecurity chain for these very sophisticated companies. And so the hackers are trying to access the information at that point. I don't think the automation of legal services really adds to the problem beyond what already exists. So I think cybersecurity is a problem in every industry, in every form, throughout legal. I'm not sure that there are any new problems that are created, except perhaps the possibility that a private company, which is not bound by the duty of confidentiality, could use that information, sell that information in ways that a law firm would be ethically prohibited from doing. So it's not a cybersecurity problem. It might be a regulatory problem that I think could be addressed, but it's not a cybersecurity issue per se. It's more of a regulatory.
Sure. Before we let Dean Perlman go, can I ask a couple of favors? One, where can students in this class, say, find you on social media or figure out where you're talking or what you're up to? And two, you haven't been prepped with this. Is there an ask you have of them, something for them to read about, watch, think about, so that they can get deeper into this space, other than to show up attentively to this class?
So in terms of reaching out to me, just Andrew Perlman, Suffolk, Google it. You'll find my website, email address, social media. So that's pretty easy. In terms of my ask of all of you, I'd love to hear what you come up with. to know what projects you developed as a result of this course. I'm very eager to hear it. I'm sure you have ideas that are at least as good as the one that Daza thinks is so wonderful, and I want to know what they are. So please share them with me. That's my ask.
Okay. Well, and Andrew, you are going to be with us on October 31st, the second day of the conference. So one thing we can do, subject to how Yost works out the projects, is those of you that choose to do projects and present them at the end of the class, we can make space on the agenda for our big conference where projects from the class can be presented for feedback. And while you're there, Andrew, we can make sure that you have a chance to actually hear the students give the project pitches.
That sounds
so
good.
Hopefully there'll be room in there somewhere in the schedule to find the right calibration where everyone can do that, since you'll be right back in this building across the hall.
Excellent. Well, thank you for having me. Good luck with the course.
Great idea. And while I do hope we can share the things that come up in a class with the dean, I hope it's a two-way street, that he's perhaps in one of the best positions to offer tips and suggestions, a la future hackathon ideas. Listen, I want to just give you a little bit of context for the class, and in particular for those of you who were excited to do the outside of the classroom part, which is to say the exploratory projects. And we also want to get you all to know each other. This is a short link. It's actually at the bottom of the class webpage, which we'll revisit in a minute. This class is only one of a handful of future explorations that we've done here at the Media Lab that are about thinking about the inventions that are changing how we live in the future, and then applying them to these market supersectors, the way we as billions of people planet-wide are engaging with problems. One example is around reimagining how we source products and materials in a sustainable fashion. Two other examples are about how we reimagine financial services, fintech innovation, and how we deal with all things human health. And then we've also drawn lessons from the world of science fiction. These 4 example future classes are the precursors to what you're now experiencing in this half-semester offering. I also want to spotlight that over the course of 150 years, this institution within Boston has graduated people who've started thousands of companies like these. And I want to call your attention not to the specifics, but rather realizing that entire industries have been rebooted because of the enabling technologies. And this one in particular I want to spotlight, because today many people know about business process outsourcing, things like Infosys, companies of that sort that have taken things that were done locally and removed the constraint of geography. Patney did his business studies here and founded what became the very first of the international offshoring businesses. He completely disrupted the sector. The Infosys people were former Patney folks. And he started it here in Kendall Square and in Bombay, Mumbai. What's the legal version of that? Because this is the kind of scale of disruption we're talking about now. It's not just these alums that are historically amazing. These are things that were born in places like this classroom. These are student ventures. And I want to just point out that there's hundreds that are collectively worth tens of billions of dollars today in public markets. But I want to spotlight one in particular. It's Direct Hit Venture. Direct Hit is just one case example of a company idea born from an exercise much like this. Gary Cullis was up the river at Harvard's law school. He'd been a patent clerk in DC, frustrated with the lousy nature of search, and said, surely we can do better. And this is now before Google, you realize. This is an early instance of the idea of search applied to a specific subsector. But the fact of that original problem inspired the creation of Direct Hit, which later sold for $500 million to Ask Jeeves. It's now the power behind Ask.com. There are other examples from sister versions of this class around reimagining how we do prior engine, the reimagination, about creating life coaches, not just wills, but other domains, legal and advisory practice. This notion of a legal guidance chatbot, and bringing simple AI to bear on the kinds of things that we all need to deal with. The world of AI is changing how people will need to deal with the legalities, the consequences of, for example, AI robotic accidents. Who's liable? These are all open questions that people in past classes have touched on. And this is what we'd like you to do here. Just yesterday, this case example of the Equifax failure provoked this notion. Why don't we do a sue bot? why not enable many, many people who are now affected by this to have a reaction? What's your version of that? Well, in this class, we're going to be here in the room listening to people who are in the thick of doing it, people whose ventures are actually in the process of building some sort of a law-oriented new solution. We ask you all to do a project that explores a domain you care about. And then there's a pile of things that are beyond the hour and a half every week in the next 5 weeks. We want you to pick one of 3 flavors of deliverable. First flavor is the canonical one around here, which is think of a new startup idea. Or think of how an established company ought to create a new practice area business unit. Second is try mocking up a prototype of something. And third is say, let's step back and assess the big picture of an area. Now, you could pick any or some combination of these. Many of the questions that you ask the dean have implicit in them exploratory roadmap domains, right? Reimagining how ownership of future law service companies could be done, thinking about alternative jurisdictions, and so forth. Flip around those questions, turn them into project concepts. Those will play out over the course of the semester. We want to hear your best ideas in the upcoming week or two, or at least see them. We'll share them online. Ideally, you band together and you do this not alone, but with others, ideally those with complementary skills or at least shared interests. We want you to iterate. This is a really short half semester. We're talking about a handful of sessions. So this is not going to be some final end product that you're going to be raising a pile of money on right away. No, what this is first draft. But because we're very practical here, we want the format of whatever you do to be immediately useful beyond the class. For instance, it could be in the format of one of MIT's competitions, or one of the competitions in the Boston metro area, think Mass Challenge. So if your draft of what you do in the class is already immediately relevant to something beyond the class, you get 2 for 1. For some of you, you're not going to do a venture plan, but you're going to do something that we aspire for you to publish, because why not reputation build and have some practical consequence that's not merely a grade in the class. We want you to have it be relevant immediately. So this plays out very quickly over the next month and a half. All this stuff, including these slides and a variant on what you saw earlier from Dean, will be online on the Stellar site. Let me just point out that this is the core MIT page that we point everything to. Everybody should have access to it. It's currently spelled out as open to all. We ask you to go to the bottom and fill in this Google survey that says, okay, who are you? Here it is. That'll all be summed up on a, thank you, Lucas, for already adding yourself. This will all be summed up on a sheet that you all can see. So don't put anything super confidential in there, although it's not intended to be spread beyond the class. And then on the Stellar website, under materials is where all these things are. Everything from the working syllabus, the calendar of who we've got coming over the next few weeks, and all the materials you're going to need. Finally, this proved to be the simplest way to get the maximum number of people to easily opt in to a non-confidential space for sharing latest stories, latest articles, latest concepts that are not don't be sharing your very best confidential idea. That's for internal class stuff. But this Facebook page could be a nice place to just throw out lots of examples of recent news stories and whatnot. So this is a really good, fast way to parallelize and share lots of things that we all may care about. So please add yourself to this. Click that, and we will approve. All right, finally, in a minute, let me spotlight Facebook page. Everybody can do well in this. This is not intended to be a curve, and all the projects should be just provocatively interesting. So let's revisit some of that. What are the projects? Look, each one of these, we want you to float in some way in the upcoming week or two. And we suggest this idea pitch schema. It just gives the high concept on one slide, just because it's the easiest way to rapidly get everybody to see everybody else's thinking. But we have to hurry up because we only have a month and change to do anything. So here's the template. This is tends to be structured for a new venture idea. So it's framed around here's a problem we're solving. Here's why I think we'll solve it. But there's also room for uncertainty. Here's the open questions that we don't yet know about. But this is essentially the format of a business plan executive summary. This is the essential format that essentially all of the competitions or places for getting early grant financing, right? There's hundreds of thousands of USD available for grant, that's free money, gift money for prototyping of new ideas. But you have to organize yourself enough to make a compelling case to get at the money. That's what we want you to think about this class is for. Now, what kind of ideas? This is what I want to conclude with, because there are dozens, hundreds even, of domains of change that are relevant for this class. So we hope that you will either step back and do some kind of roadmap, or hone in and do some sort of mock-up or early prototype, or think, what's the new venture, the alternative way of structuring delivery of these services? And there's so many. I just give you some as provocative examples, but the questions you heard earlier are indeed basically slight variations on proto-idea pitches. We also want you to engage with us, whether it's by email or chat or whatever. Float your proto-ideas. Don't feel free to be embarrassed in the class, because we don't care. The idea is that you propose one thing, other people propose others. You may mash together. You may end up dropping your idea. You may end up recombining to a third idea. But it's everything from just rethinking, what does AI and all of the tools for automagic interaction mean for the provisioning of legal services? It could be taking legal property domains or jurisdictions and saying, what do they enable that people haven't really pushed the extremes on? Law of the sea is a good example. I like it. Why? Because a ship has amazing legal status. But are there any limits to the scale of a ship? Could we have multiple cubic kilometer ships? This is really pushing the historical traditional definitions, but in a way that's now technologically possible. That's the kind of stuff we want. There's now a space initiative at the Media Lab. What about law of space? Who owns what, where? Are there new things that are increasingly going to be important as we have multiple private organizations that are doing space, increasingly heavy lift? Huge, interesting new domain, or relatively accessibly soon to be available domain. What about this jurisdictional arbitrage idea? Are there in fact places where it's better to be doing your business? It's better to try things out first. It's better to be an early adopter in some place. Why is it that we have things like incorporation in Delaware or ship registries in Panama or Liberia? Are there other things of that sort that are plausible in the future? What are the new rights domains that we haven't even touched on? This lab's fastest changing stuff is not about the classic world of code or even the world of things, the making, but instead the world of biology. The newest professors here are interested in DNA as a substrate for data storage, for computation, for editing organisms, hacking us. Okay, whose rights are where in this whole landscape? Similarly, the world of artificial intelligence. We laugh about it, but do robots and artificial entities have any kind of rights? Are there constraints on them? What are those emergent domains? Yeah, the list goes on. This little nugget at the end, the idea of doing a natural language processing on not just a ruling, but maybe an entire corpus of historical rulings, maybe comparative linguistic analysis between different jurisdictions. Maybe it's across the 50 US states. Maybe it's internationally, maybe in the Commonwealth Anglophone states or in other jurisdictions. All this stuff and more. The world of these new technologies like blockchain applied to reimagining contracts or asset registries. All huge stuff. We get the Digital Currency Initiative here, cares about these things. All territory that is a potential super theme for a 1 month intensive outside of the classroom project affiliated with Future Law. And this is your excuse, your all-purpose excuse to talk to whoever you need to, because you're doing an academic exercise on these questions, and to explore these questions and just stitch it together into a format that matters to you. Draft of a paper, that could be innovation roadmap. A prototype that gives people a taste of what a future tool or service might look like. That's second case option. And then third case option is, what's the new startup that you start your planning on, or you at least make progress on a plan towards here in the next month and change. Okay? that's the project side outside class. Question?
So I have a project I'm going to propose for sure, but I also have a bunch of ideas that I just want to kind of propose to the group as well.
That's all fair game.
Okay, I want to make sure I can do it.
Absolutely. And, people, clearly there's more ideas than there is time or capacity to pursue. So people have multiple ideas. Best to put them out there and get other people to, in some sense, crowd rank, right? Sometimes your second idea is actually the crowd's bigger idea, and you get motivated to do that. Why not? Look, we're here for a half semester. This is a completely exploratory realm. Use this as an excuse to do what you think is most intriguing, and also so in other words, you have to go deep on something, but also to flow widely what range of things you find most interesting. Because that's also a sort of a vote ranking mechanism. Other questions about this stuff? Gabe, any comments on this?
No, sounds perfect.
Yes.
So in terms of next week, are we bringing the ideas class?
People can start pitching as early as next week, and we'll see a little bit about the time because we want to pack a lot into the classroom. So we may end up, over the course of the next 2 weeks, be floating your ideas. Those with ideas, get them in now. But we may end up sharing the bulk to the class via the Stellar site. We'll see how much time we actually have in the room. Just, if we have a guest speaker here, we're going to talk about their stuff with priority. Yeah? Other? Okay, that was, we're done. Daza?
Yes. I guess one little thing is, I know a lot of you have said that you can't be here for every class, but you'd like to participate. And